people.
Sorry to interrupt the honourable member. Dr Russell Norman.
Thank you, Mr Speaker. I rise to speak on the Financial Markets Conduct Bill on behalf of the Greens. I think we probably should start this with a bit of an apology on behalf of the New Zealand Parliament to all those people that invested in finance companies. This Parliament failed you. It's a simple fact. We didn't regulate the finance companies, and we should have. A lot of people invested in finance companies and lost vast amounts of money, retail investors, and this Parliament, over many years, let that happen. This Parliament failed to regulate the finance companies in a way that it should have, and the result is that many New Zealanders have lost their retirement savings, and many New Zealanders worked day and night for decades in jobs saving money for no purpose in the end. It is as if we took away a chunk of their lives by not regulating the finance companies properly, which is our job, because we are legislators. And so day and night, people worked in jobs, put money aside in finance companies because they thought they were saving for the future, and they assumed that this Parliament was doing its job. That is, to regulate the finance companies so that they wouldn't lose all their money. But this Parliament wasn't doing its job, and that is the sad truth. So this bill is a response in some respects, though it's more than that, to that failure by the New Zealand Parliament. Now, I think that there's a lot to be there's a lot to like in this bill in terms of the attempt to establish a kind of comprehensive framework around financial services and financial markets, particularly obviously protection for retail investors, but not only retail investors. But there are some questions around it which I think that that really come to the surface when we're looking at what we're proposing to do in this bill. And the fundamental one is that we are essentially weakening the penalties around directors of finance companies. It's hard to believe that this bill weakens the penalties applied to the directors of finance companies if they mislead investors, but that's actually what the bill does. So currently we have a strict liability regime. You put out a product disclosure statement which misleads investors. You can end up in court under a strict liability. It's not about intent. It's just you end up in court and get convicted of that. We're, in this bill, proposing to replace a strict liability regime with one of, essentially, you only come under the criminal provisions of this bill if it can be proved that you were deliberate in misleading people or that you were reckless. So we've moved from a situation where, as we've seen with some of the recent prosecutions, the directors of companies who put out misleading prospectuses and misled investors and resulted in the loss of their retirement savings of many millions of dollars for many tens of thousands of New Zealanders. We're moving from a situation where we had strict liability for their actions if they signed off misleading prospectuses. Under this bill, they'll only have civil liability. That is, they won't go to jail, they won't face jail time, unless it can be proven that what they did was deliberate or reckless in signing off a misleading prospectus or a product disclosure statement, as it's called. And the question we have to ask is that right? Is that good policy? Is it right that we should say to the tens of thousands of people who essentially have lost great chunks of their lives where they worked for hour on end in order to put nest eggs together to save money, and basically they gave that money to a finance company based on someone who they respected signing off the statement saying that it was true. They gave the money to a finance company, and then all of that time and all of that work that that person put in was essentially taken from them. It was taken from them when those finance companies went belly up. So we took a whole bunch of their time, and a whole bunch of their work has just gone up in smoke. So hour after hour, working late, maybe doing overtime, whatever it was, how they got their money together for their retirement nest egg, we've just burnt it. And the directors of the company who signed off that misleading prospectus effectively took that time away from those people. And so we're saying, OK, if you signed off on that statement and you took the time from those people's lives, the time that they could have been spending with their kids, doing something they liked, maybe, instead of working, so you took the time from those people, but you're not going to suffer any criminal time. There's not going to be any time taken from you. You're not going to go to jail because we're now changing the law so that there's no longer criminal provisions, but just civil ones, unless you can prove that it was deliberate or reckless. So we're saying you can take that time from those people essentially removed the time that they had. But under this bill, unless we can show that it was deliberate or reckless, you're not going to suffer any jail time. There's just civil liability and civil provisions. And is that right? Is that ethically right? And I think that's the question we have to ask in addressing this bill. For that reason, the Green Party won't be supporting the first reading of this bill because we're not convinced that it is right. We're interested in having the debate at Select Committee, and we recognise there's a lot of good stuff in this bill, no question about it. But on that basic ethical question, is it right what the Parliament's proposing to do with this bill? I think we have to say at the moment we're not convinced that it is, and we're pretty sure it probably isn't. Because that change from from a criminal strict liability to a civil liability, unless you can show it's reckless or you can show that it was deliberate, we think is a very, very important change, and we're not convinced that it's the right change to make. The other question is, will it help the capital markets? There's no question that systematising the regulation of these markets is valuable. And so we can see that the bill does make a contribution. But if a key part of the capital markets are the retail investors, who together add up to quite a lot of money, does this give the retail investors the confidence they need to re-enter the retail investment market? And when they see, and when they come to understand, and eventually they will, that what we're proposing to do is actually weaken the penalties for directors of finance companies, I don't believe that their confidence in the retail investment sector will be improved. Now, part of it is understandable. People want to punish someone, and you could argue that these retail investors, are behaving in an emotional way because they want to send people to jail and strip their knighthoods and all that kind of stuff. And okay, that's fair enough. But it's also true that if a system is to have teeth, if the system is to have real teeth to make sure that it actually has the effects that we want, that's the reason why we put jail time in bills. There's all sorts of bills where you can end up in jail. If you steal from someone, relatively small amounts of money as a burglar, then you can end up in jail. If you steal from people many, many millions of dollars because you sign off on a misleading prospectus so that a whole bunch of retail investors lose their life savings and many millions of dollars, we're now saying you won't go to jail unless we can prove that it was deliberate or reckless. Now, there's actually some commentary in the media about whether in the most recent cases actually that test would have been met, and I'm not going to speculate on whether it would have or not. But if we're saying to retail investors as a parliament, we are now weakening the penalties for those who take your money by offering misleading prospectuses, I'm not convinced that that really does help our capital markets in terms of encouraging small retail investors to get involved. Now, this same kind of test, and the provisions around this test also apply to insider trading, and the penalties around insider trading. Are there criminal penalties? Well, it depends. You've got to be able to prove that it was deliberate or it was reckless. Market manipulation is the same. So the same kind of test has been applied in a similar way right across the different kind of provisions of the bill, and I think that makes sense to apply it in a consistent way. The question is it the right test that we should be applying to those who are doing these things? The other part of it, I think, which is interesting, is around the compensation. There's some good aspects around trying to actually enable compensation in this bill. The thing is that often when it comes to the finance company collapses, there actually wasn't a lot of compensation to be offered. So that while this bill may result in better ability for people to get compensation out of the system after the collapse of something like a finance company, whether that really helps the retail investors at all is another question, because often the money's not there, or there's not very much money there because it's all gone. So while the compensation provisions are good, whether it will really help retail investors, I don't know. It's not so clear. So from the Green Party's point of view, those are our concerns about the bill. We won't be supporting it at Select Committee. We'll be engaging, we won't be supporting it at first reading. We'll be engaging with it at Select Committee because I think that those questions go to the heart of this bill and the heart of the confidence that people have when they invest their money with companies like the finance companies. Thank you, Mr. Speaker.
I call Kanwaljit Singh Bakshi.
Mr. Speaker, I stand to speak